Sharf, director of the Cox Center, and you're in for a real treat. We're going to begin with an introduction by the Associate Dean Hiram Chodosh. Then we have Henry King, who is one of the former Nuremberg prosecutors and a professor at Case Law School, who will do an introduction of our special guest lecturer, Philippe Kirsch. Then I will be presenting the award, the Humanitarian of the Year award that we are doing, and Philippe will speak for about a half an hour, keeping 15 minutes reserved for question and answer. And then at the end of this program, we'll be adjourning across the hall for a reception, and you can ask any questions you want. Without further ado, then, let me present the Associate Dean of this law school, the former director of its International Law Center, Hiram Chodosh.
Thank you very much, Michael. On behalf of Dean Jared Korngold and my dear colleagues here at the law school, I'd like to welcome you here today. Dispensing with a more conventional introduction to our global programs, I'd like to proctor a pop quiz, and I'll even make it multiple choice as a way of introducing you to our most innovative initiatives. Name the school that offers the following mix of innovative global programs. A first-year perspectives course, Global Perspectives course now in its 14th year, a concentration in international legal studies in its 6th year, an offering of over 38 courses, 2 of the oldest international law journals in the country, one now entering its 38th year, 6 clinics and labs in immigration, war crimes, judicial reform, global corporate governance, international financial integrity systems, and counterterrorism, with students providing dedicated research to each of the international war crimes tribunals, the International Monetary Fund, the World Bank, and the Department of Defense. 3 moot court teams, including a regional champion Jessup team, the Jean Bictet International Humanitarian Law team, and our own Niagara competition on U.S.-Canadian legal issues. The prestigious Klatsky Fellowships at Human Rights Watch, and summer internships that have sent up to 20 students all over the world each summer. Study abroad fellowships with students in Vietnam and Sierra Leone this past fall, a new Fulbright partnership in India, an LLM master's program that has educated over 350 foreign lawyers in the U.S. and will offer the first U.S. LLM in Beijing. Over 2/3 of the faculty engaged in global research, teaching, and public service, including our own Henry King, a former Nuremberg prosecutor, and Michael Sharf, our distinguished Nobel Peace Prize nominee. Over 270 publications in international, transnational, and comparative law in the last decade. The pioneering Canada-U.S. Law Institute, founded over 30 years ago. 4 of the leading blogs and portals on war crimes and counterterrorism. A symposium and lecture program that brings over 40 of the world's leading international law and global justice experts to campus each year to engage the most critical issues of our day, from intellectual property to new medical technologies, from nation building to war crimes and bioterrorism. Today's host of the first U.S. lecture by the President of the International Criminal Court, and to add one more counterintuitive clue, a venue sporting blue skies, sunshine, and a high of 60 degrees here on November 7th. Which school can claim these exciting and innovative programs? Is it NYU? Is it Columbia? Is it Georgetown? Is it George Washington? Or is it here at Case? I'll leave it to my dear colleagues, Henry King and Michael Sharf, to provide the answer key. And for those of you who've answered correctly, you'll have the pleasure of an inspiring lecture over the next hour. So I turn it over to our own national treasure, my hero, Henry King, to introduce our distinguished guests. Thank you very much.
Well, it's indeed a pleasure to be here today to introduce our speaker, Philippe Kirsch, who is the president of the International Criminal Court, which is the first new international institution created in the 21st century. As a former prosecutor at Nuremberg, I think it's important that society progress through individual proceedings like Nuremberg, but I also feel that progress has to be institutionalized beyond a single instance or beyond the geography of a particular proceeding. Nuremberg and the ad hoc tribunals at The Hague and Tanzania were a start, the International Criminal Court will make the principles of Nuremberg a permanent part of our international landscapes. I was at the Rome Peace Conference, or the Rome Conference of 1998, 1998, which created the International Criminal Court. I saw the work of Philippe Kirsch as he built a coalition of like-minded countries which were directed at the success of the conference. I saw the U.S. attempts to derail the conference. The conference was settled to end on July 17, 1998. Philippe Kirsch was the conference chair. He asked the Committee of the Whole to produce a draft of the statute by July 15. On July 16, he distributed the draft to the conference participants. And on July 17, in a very daring maneuver, he proposed an up or down vote on the proposed statute. The result was resoundingly in the affirmative. 100 countries are now members of the court. And Robert Jackson, the chief prosecutor and architect of Nuremberg, were he alive today, would be proud of Philippe Kirsch's achievements. So it's an honor, a pleasure to introduce Philippe Kirsch here today. Philip, the floor is yours. Thank you very much.
You can stand next to me, Philip.
Okay.
I have been privileged to have known Philippe Kirsch years before he was the president of the International Criminal Court, when he was working in the trenches so hard to create this international institution, and his successes are a tribute to his brilliance, to his determination, to his creativity and ingenuity. The International Criminal Court is likely to be one of the most important institutions in the world in future years. And now that the United States has acquiesced to having the Security Council send its first case to the International Criminal Court, implicitly recognizing the legitimacy of the court, there is a new dawn, I believe, in U.S. ICC relations. And it is a great honor and privilege for us at CASE to have Philippe Kirsch come here to our law school to speak to us about the importance of this institution and its direction in the future. Every year, our law school gives a Humanitarian of the Year award. It was created just last year, and the first recipient was Hans Corell, who had been the legal advisor of the United Nations for 10 years, and also a great contributor to many international tribunals. This year, our recipient of Cleveland's version of the Nobel Peace Prize is Philippe Kirsch, and the award reads, International Humanitarian Award for Advancing Global Justice, presented to Philippe Kirsch, President of the International Criminal Court, on November 7th, 2005, at Case Western Reserve Law School.
Thank you very much for those introductions, Henry and Michael. I'm very honored, of course, to have received this award. I'm also very proud that I think I got the quiz right immediately, with some effort. And of course, I recognize that this award is not only to me, but to the International Criminal Court itself, the significance of its creation and of its establishment. And there's music coming with it. It's fantastic. I'd like to say to you a few words about the ICC, which is not a really new idea. It's an idea that really started a few centuries ago. It was mused about after the First World War, but it really was developed in the aftermath of World War II. But because of the Cold War, it languished for about 50 years. It was reborn with a flurry of activities in the 1990s. And there is now really a new system of international criminal justice, with the International Criminal Court standing at its major institutional development. I think Henry referred to this, and I will get back to to that aspect a little later. I'd like to talk about four aspects of this system and its development. The efforts which eventually culminated with the establishment of the ICC, the features of the court today, and what we should expect from the court in the future. I think really the story of the ICC starts during the latter years of the Second World War, when the Allied powers were debating what to do with high-ranking Nazi officials. In large part because of the insistence of the US government, in particular the chief negotiator and Supreme Court Justice Robert Jackson, the Allies decided to conduct trials for those accused of crimes against peace, crimes against humanity, and war crimes. These trials would protect the due process rights of the accused. So eventually these trials included the International Military Tribunal at Nuremberg, its sister tribunal at Tokyo, and other trials such as those conducted by Professor King and his colleagues under Control Council Law number 10. Out of those trials came two overarching principles. First, individuals, not only states, can be accountable for serious atrocities. And second, individuals should be held accountable for such atrocities, as impunity cannot be allowed to prevail. The trials established important precedents in substantive and procedural law, and we do owe today a great debt to Robert Jackson, Professor King, and all those who invested so much effort to make those trials a success. And that created what is often referred to as the Nuremberg Legacy in international law. And the international community saw different ways to enshrine that legacy to these days. I guess the first example was the Genocide Convention and the early work of the International Law Commission, which envisaged the establishment of a permanent international criminal court to try perpetrators of the most serious international crimes. As I said earlier, the Cold War prevented the creation of any such tribunal. And during that time, during the Cold War, mass atrocities were committed and remained unpunished around the world, Cambodia under Pol Pot being just one example. Now, naturally, and I'll get back to that point later in the context of the ICC specifically, naturally national courts do have the first responsibility to deal with any crimes, including the most serious crimes. The problem is that it is precisely when you face the most serious situations, the gravest situations, that the national courts are least likely to respond effectively. And so, without an international tribunal to act where national courts would not or could not, the perpetrators of the most serious international crimes were protected by impunity. With the end of the Cold War, the idea of a system of international criminal justice was reborn. In 1989, which happens to be the same year as the Berlin Wall fell, the UN resumed its work on the establishment of a permanent ICC. And of course, at that time also, as the debate had already begun, the world witnessed two new situations where massive crimes were committed in the former Yugoslavia and in Rwanda. In each case, the UN Security Council established an ad hoc tribunal to deal with those crimes. Like their predecessors, the objectives of those ad hoc tribunals were actually including a number of goals, including restoring international peace and security and national security, punishing individuals responsible for the most serious crimes, bringing justice to victims, and over time contributing to deterrence of potential perpetrators. Those tribunals showed that were pioneers, and they showed that international criminal justice was a practical possibility. But as I think was alluded to by Professor King, ad hoc tribunals by definition face very serious limitations. They are geographically and were geographically limited. They respond primarily to events in the past. Their establishment involves substantial costs and delays during which, for example, evidence and people disappear. And last but not least, their creation always depends, every time, on the political will of the international community of the day. And so, as Professor King said earlier, a permanent, truly international court was necessary to respond to the most serious international crimes and to overcome the limitations of the ad hoc tribunals. And then, as Professor King said, in 1998, the conference was convened that would establish the ICC. I think the first thing that should be understood about the ICC is the importance of the fact that it was created by treaty. It was not something that was imposed by military powers or by the Security Council. It was a choice of states to create their own international court of which they would take ownership. So there is indeed a commitment by states which are party to the system or interested in the system that never existed in ad hoc tribunals because of that. All states were able to participate in the drafting of the statute and other texts. States are free to join or not to join the ICC as they see fit. And of course, because a treaty only binds the states that ratify it, it was essential to build widespread and deep support for the statute, and that remains a long-term indispensable objective. In Rome, 160 states participated in that conference, and those states sought wide agreement on the statute of the ICC. The statute eventually was adopted and approved by 120 states, with 7 voting against and 21 abstaining. Then came a preparatory commission that met for over 3.5 years, which was charged of developing other instruments that the ICC needed to function, including the rules of procedure and evidence and what's called the elements of crimes. I should add that the US delegation was an active participant, both in the Rome Conference and in the Preparatory Commission, drafting the rules of procedure and the elements. And I should add also that at the time where the two most important instruments necessary for the ICC to function were adopted, that is, the rules of procedure and evidence and the elements of crimes, the US was present and participating. And for 3.5 years, all decisions in the Preparatory Commission were taken by general agreement. There was not a single vote. And I think in terms of importance of those basic instruments, that fact, the American presence all the time, and the consensus adoption of the instruments is quite significant for the future. And that effort to adopt all decisions by consensus was already shown at the end of 2000, when the deadline for signature came. And by that time, 139 states signed the statute, which is about 20 more than those who voted in favor of the statute in 1998. To my knowledge, it is the first time in the history of international negotiations that there were, in a short time, more signatures than votes. Because normally, the easy path is that states vote for something, and then they forget about it. Especially when it comes to such a complicated and demanding system as the Rome Statute and participation in it. So I think what happened between 1998 and the end of 2000, the recognition by many states that their voice was being heard, that the statute and all these instruments had to reflect not one system, but a combination of systems to make the best possible system acceptable to all states, was recognized. 7 years after the adoption of the Rome Statute, 100 countries have ratified or exceeded, the last one being Mexico a couple of weeks ago. This, I think, is a remarkable pace for a treaty establishing an international institution, particularly an institution that has the potential to look at what national systems do. Now, the features of the court. The ICC, in some ways, lives with the history of international criminal law elsewhere, and it is not always in to its advantage. The ICC lives with the history of the international tribunals, which have faced their share of problems. The ICC also lives with what happened in national jurisdiction, which was not always popular. For example, these certain examples of application of universal jurisdiction. So the ICC is developing with that historical baggage. And I think the first point that is important to understand about the ICC is to dispel one common, a fundamental misperception, which is that the ICC does not have universal jurisdiction. Its jurisdiction is limited to crimes on the territory of states parties or committed by nationals of states parties that have voluntarily consented to the jurisdiction of the court. Anyone studying criminal law will recognize in those two grounds, the nationality of the accused and the territory of the crime, the two classical, firmly established bases for criminal jurisdiction. But that also is the reason why wide ratification is so indispensable. It is not only a matter of principle because the court was created by treaty. It is also because if you apply those two criteria, nationality of the accused and territory of the crime, you can see that as long as there is no wide ratification, a lot of situations potentially escape the jurisdiction of the court. A simple example is that in the case of an internal conflict, which internal conflicts are within the jurisdiction of the ICC, the state of the nationality of the accused and the state of the territory of the crime happens to be the same state. So if that state is not a party to the statute, clearly there may be wide areas escaping the jurisdiction of the court. The court's jurisdiction regime also recognizes the special role of the Security Council in maintaining peace and security. The Security Council can refer situations to the court. It no longer has to create every time an ad hoc tribunal as it did for the former Yugoslavia and Rwanda. And of course, you are aware that the Council exercises that power by referring the situation of Darfur in Sudan to the ICC. The Security Council also can, acting under Chapter 7 of the Charter, the UN Charter, defer investigation or prosecution for a period of 1 year. The court's jurisdiction is also limited temporally. The court has jurisdiction only over events that happened before the 1st of July 2002, which is entry into force of the statute, which is when the jurisdiction of the court begins. The subject matter jurisdiction concerned covers the most serious international crimes: genocide, crimes against humanity, and war crimes, crimes that are well established in customary and conventional international law, as well as in national laws. The statute defines those crimes in significantly more detail than the statute of the previous tribunals, because you have to remember that when the court was created in 1998, the states had no idea over what the court would exercise its jurisdiction. It was unpredictable. And so the states had a great interest in ensuring that the courts would not cause them bad surprises, such as inventing law, or taking decisions for political reasons. So the states were very careful to circumscribe the scope of activities of the Corps very, very carefully, in much more detail than they had done, or the security had done, for other tribunals. Those definitions of crimes were supplemented, as I said earlier, by what's called elements of crimes, which was an initiative of the American delegation in Rome, which sets forth the elements of each crime. By that, I mean the environment. For example, you cannot, if you commit a war crime, you have to be in a situation of conflict. The act itself, the intention of the perpetrator, and all that. I have to tell you, at the time, everyone hates that idea, because no one understood what element crimes were. This was a very particular to the U.S. system, and there was a great deal of resistance to adopting elements of crimes. In retrospect, I think it was an excellent idea. It does indeed provide additional detail and clarity to the definitions of the statute, and it also updated some concepts that had been adopted decades ago, but of which the formulation was not quite right anymore. So I think the elements of crimes, this American initiative, will be very useful for in the application of the jurisdiction of the court. There's another crime that is listed in the crimes covered by the statute, in addition to the three I mentioned, which is the crime of aggression. But in this case, the court will not exercise its jurisdiction until both a definition of aggression and conditions for the exercise of the jurisdiction are agreed upon. And this has to be done through an amendment to the statute. At the earliest in a review conference, which is due to take place in 2009. Now, why is that? Aggression was included in the statute because many states thought that if there was no aggression, many other crimes would disappear automatically. Many war crimes would not disappear, and all that. But at the same time, there was absolutely no agreement about what aggression was, how to define it for the purpose of criminal jurisdiction. Of course, it was defined by the General Assembly in '74 as a kind of guidance to the Security Council how to determine an act of aggression, but there was no definition that could be applied criminally. So that was one problem. The second problem relates to the conditions of exercise of the jurisdiction of the court. Now, what does that mean? That means that before an individual can be accused of a crime of aggression, you need to have an act of aggression in public international law, a state committing an act of aggression against another. Who determines that? Well, in principle, it should be linear. It should be very simple. The UN Security Council determines that there is an act of aggression that has been committed, and then the ICC takes over to try the individuals who have been involved. The problem is that that was not anticipated. And since the creation of the UN, the Security Council has very carefully refrained from determining acts of aggression, except in very, very few cases. One obvious case where they did not do it was the invasion of Kuwait by Iraq. They deplored the use of force, they said that measures should be taken, but they did not say there had been an act of aggression. So what its state concludes that maybe the Security Council will never do it, and that therefore you need something else to do it, some other organization that could determine that act of aggression before the individuals can be tried. Now, what could that be? It could be the ICJ in an advisory opinion, the International Court of Justice. It could be the ICC itself, God forbid. Or it could be the UN General Assembly, and that would, I think, entail its own share of problems. Upon which the permanent members of the Security Council say never any alternative. The Security Council is the organ that has exclusive jurisdiction, and that's that. And there we are. So maybe in 2009 at the review conference there will be agreement on those points. Maybe they will not be there. I'm going to finish my term as judge in 2009, so it's not going to be my problem. But it's still an interesting issue. Now, another feature which is really important is that the court is really a court of last resort. It is only intended to act when national courts are unwilling or unable to do their own job, exercise their own jurisdiction. That's called the principle of complementarity, which my computer always tells me that I don't know English every time I type this word, because of course it doesn't really, it's not a very classical word, but it's a very useful word in the ICC context. Under that principle, a case will be inadmissible if it is being or has been investigated or prosecuted by a state with jurisdiction. There's one exception. This is an exception. There is an exception when the state is unwilling or unable genuinely to carry out the investigation or prosecution. For example, unable is you have had an internal conflict. The judicial system of states has collapsed. Well, there's nothing no system that can try people, so the ICC can take over. Or the proceedings are undertaken, but the proceedings are undertaken solely to shield a person from criminal jurisdiction, or proceedings are carried out in a manner inconsistent with an intent to bring the person to justice, or there are so many delays that it is obvious that there will never be a conclusion to proceedings. This is the unwilling part, and this is where also the ICC can exercise its jurisdiction. And of course, a case will be inadmissible if it is not of a sufficient gravity to justify action by the court. States and the accused always have the right to challenge the admissibility of a case. I will not comment on the procedural regime of the ICC. It does contain elements of different legal systems. The statute and the rules of procedure contain detailed protections of the rights of the accused and the principle of a fair and public trial. To an American audience, to make this short, I suggest watch Law and Order a few times. You'll see what I'm talking about. You will find all these principles in the ICC statute, drafted a little bit differently, but the result is exactly the same. Now, the court today, 3 states parties have referred situation occurring on their territories to the court. Uganda, in the case of the Lord's Resistance Army, Congo, the Democratic Republic of the Congo, and the Central African Republic. And then, of course, the Security Council referred Darfur to the ICC, because Darfur is a non-state party. In July, the first arrest warrants were authorized in the situation of northern Uganda for 5 members of the Lord's Resistance Army. For any of you who do not know who that is, what that is, it's an organization which allegedly has committed massive crimes for the past 20 years, particularly against children. They kidnap children, or they allege to kidnap children, and commit crimes such as sexual enslavement, rape, forced enlistment, slavery. They also allegedly force children to commit crimes against one another, which means that from the victims that they are initially, they soon turn into perpetrators of crimes, albeit unwittingly. But this creates obviously a tragic situation. Those arrest warrants were initially under seal because of concerns about the security of victims and witnesses. They were made public in October after the pretrial chamber, which issued the warrants, were satisfied that the court had taken adequate measures to ensure security. This is something which is very particular to the court. In almost all practical situations being covered by ad hoc tribunals, they dealt with crimes that had been committed, often in the course of conflicts that had ended. The ICC has to deal, at least now, with crimes that continue to be committed in the course of conflicts that are ongoing. And that creates tremendously difficult practical problems for the ICC. So the court has to face those security concerns whenever the prosecutor is investigating situations of ongoing conflicts. Now, to understand the role and significance of the ICC today, you have to go a bit beyond the investigations and prosecutions. In the preamble of the Rome Statute, states parties have expressed a number of objectives for the court. The punishment of perpetrators, obviously, is the most immediate goal. But through punishment, it is envisioned that the court will contribute to the prevention of crimes. That is in the statute of the ICC. Other aims in the preamble include the maintenance of peace and the maintenance of peace and guaranteeing lasting respect for and enforcement of international justice. Now I'm getting on thin ice here for just a few seconds, because talking about deterrence is not easy. How do you prove a negative? How do you prove that because of the existence of an institution, something has not happened? It's very difficult to do. So, since I like avoiding taking responsibility when I can, I will, and I will quote people. The UN Secretary General, for example, in his August 2004 Rule of Law report, says that through its mere existence, the court is already being credited with having a deterrent impact on future perpetrators. That's what he says. And then you have a human security report, a recent empirical study of the causes of conflict undertaken by the Human Security Center at the University of British Columbia, which is in a very nice country, with the support of governments and academics, which lists the establishment of the ICC as one of the factors leading to a decline in civil wars. I'm still quoting. Now I'm going to get into things that I don't think are in dispute. We get press clippings every day, the court, press clippings, concerning the developments relating to the ICC and related issues, security, peace and security issues, human rights issues, what happens in national systems. It is extraordinary when you look at that, how much notice is taken of the ICC. Sometimes with hope, sometimes with apprehension, but the ICC is being the existence of the ICC is being registered. And that is certainly a fact. Another fact is that the establishment of the court is certainly contributing to the strengthening of national mechanisms to investigate and prosecute serious crimes. Many states, including both states parties and non-states parties, have chosen to review and amend their domestic legislation in light of the Rome Statute. And that, I think, comes from probably for two reasons. One is that the ICC Statute is the latest record of what those crimes are, the list of crimes in the ICC Statute. And the other, it comes from what I mentioned earlier as the principle of complementarity, which is that states do not want to be caught in a situation where they are deemed to be unwilling or unable to exercise their own jurisdiction. So in order to ensure that they're not going to go before the ICC, states do try to improve their national legislation to avoid that. And one third impact of the ICC, which I think also is really not questionable, is that there is a renewed and strengthened international dialogue on the need and punish serious international crimes. The ICC is a regular feature of debates on a wide range of related issues, such as children in armed conflicts, transitional justice, and the rule of law. At the recent UN World Summit, governments affirmed their responsibility to protect civilian populations against serious international crimes, such as those included in the ICC Statute. There was no specific reference to impunity, and there is no specific reference to the ICC because of the opposition of a government. And that will be my own quiz. You get to guess who that government is. What can we expect from the court in the future and from this wider system of international justice? The court, of course, has the responsibility to establish its own credibility through fair and impartial proceedings and through effective proceedings. But the court will never be able to end impunity alone. Its success does depend on the commitment of states, international organizations, and civil society. Because the court's jurisdiction is limited to the national and territory of states parties, continuing ratification of the statute is essential for the court to have a truly global reach. I said that earlier. Because the court is complementary to national jurisdiction, states will continue to have the primary responsibility to investigate and prosecute crimes. And when the complementary principle does not work, that is, when the court is forced to act, then it will require cooperation of states at every stage of the proceedings, including arrest warrants, providing evidence, and enforcing sentences of the convicted. The whole system was based on cooperation. States wanted a court that was exclusively a judicial body. They did not give it a police, they did not give it an army. But someone has to go and arrest criminals. And that has to be states and hopefully international organizations as well. No arrests, no trials. Now, international organizations also provide critical support of the court. The support of the UN is particularly important because the UN has a presence in some states in which the ICC operates, and those situations are extremely, the situations are very precarious. I did sign with the Secretary General in October 2004 a relationship agreement with the UN, which provides for mutual recognition of the institutions, but which also provides for a variety of mechanisms, cooperation, information, and the like. And for example, in Congo, the peacekeeping force there is extremely important to provide logistic support to investigators and also security. NGOs have played a large role in the building of the ICC. Of course, they were the first advocates, or very active advocates, of the creation of the ICC. They have assisted states in developing legislation. They have urged ratification of the statute, and they possess enormous knowledge which is directly relevant to the court's work in the field. Now, academic institutions have a particular important role in relation to the court. In my experience, ignorance is one of the biggest obstacles to the success of the court. Often, opposition to the court is based on misconceptions which can be easily avoided as soon as right information is provided. I'll tell you a little anecdote. Which happened last year. I was in a tour conference in the United States, and I stopped in an important city, and I stopped to have a meeting with the board of editors of an important newspaper, and that quiz you cannot get. And I could see 4 people absolutely frozen in front of me when I got into the room. They were not my friends. I could see that immediately. And so the first questions were what kind of horrible things is your court going to do to poor soldiers, to poor Americans. And then I began to explain a little bit the statute and the safeguards and all that. And at the end of the meeting, the questions were, well, with so many safeguards, are you sure you could be effective? I thought that was a victory of sorts. I'm saying that because that leads me to the point that I'm really pleased that case law school takes a lead in educating faculty, students, and the broader community about the court. I'm impressed to the extent, by the extent to which the Koch Center has included issues of international criminal justice in its activities, and I note that your summer study program has incorporated visits into the court in its agenda, and we look forward, Michael, to welcoming you each year with your students. And now I think I would conclude by recalling what I said about the court being part of a larger system, and by referring again to the experience of Robert Jackson at the Nuremberg Tribunal. In his opening statement, Jackson told the tribunal, the usefulness of this effort to do justice is not to be measured by the law or your judgment in isolation. The trial is part of the great effort to make the peace more secure. And this too applies to the ICC. The ICC and other recent developments to prevent and end conflicts, that was said by the Human Security Report, have achieved only modest success in terms of their own goals, but taken together, their impact has been highly significant. The ICC is not in itself a panacea. It cannot alone put an end to grave atrocities, but it is an essential part of the system of international criminal justice, which will, over time, hopefully lead to a culture of accountability to replace this prevailing culture of impunity, and to make the peace more secure. But I think for the system to succeed, we need the ICC. This concludes my presentation, and I will be happy to get questions if there is time. However, I don't comment on the political position of states. I don't comment on specific situations. I do not speculate on what the court could do if this or that. I do not infringe on the prosecutor's territory. If you're still interested, I'm all yours.
Well, at least we can have a U.S.-style confirmation hearing, right? we do have about 12 minutes for question and answer. There are microphones on both sides, so if you raise your hand, I'll let you take care of identifying anybody by pointing. And
No, you do that.
Okay, I'll do that. And then we'll just have you speak into the microphone and ask your question. Do we have any questions back there?
Henry King.
Henry King, can you bring up the microphone? Hold on just a second, Henry. It's coming.
What about enforcement of the decisions of the ICC? Do you want to describe the enforcement procedures? And I think that's an important aspect of it. As you're getting to the point where you are going to have to enforce some of your decisions, or our decisions.
Yeah, well, the penalties in the statute range from fines to a variety of imprisonment sentences. Normally, it's up to 30 years. In exceptional cases, it could be for life. To enforce that, states have been invited to offer their detention facilities on their own territory, subject to whatever conditions they may apply. We did conclude the first of those enforcement of sentences agreement with Austria about a week ago. If you deal with a situation where no states have made such an offer, then the responsibility falls on the host state, the Netherlands, with which we are developing an agreement for those sentences. Yeah.
Next question.
Yes, I had a question about the ability to grant reparations to victims. I think most of the talk of the ICC revolves around the punishment of crimes and also the prevention of crimes, but I don't feel like there's as much talk about granting reparations to victims, which is arguably one of the main functions of the court as well.
Well, actually, then you're in the wrong circles, because there really is a great deal of talk about reparations for victims. I think it's a very good question. The ICC is the first court, international tribunal, where to which victims have access in their own right. I think that's already important to understand. In the ad hoc tribunals, victims, of course, appeared before the tribunals, but as witnesses. As essentially to prove the point of the defense or to prove the point of the prosecutors, but not in their own right. Victims can come to the ICC in their own right and have the same rights of legal representation as the accused do, with people having the same qualifications. So that's, I think, a major difference already between other systems and the ICC system. The ICC system also has created, as you say, a system of reparations which can include compensation, rehabilitation, and the like. And of course, the crimes of which we're talking, are so immense crimes that it's impossible to fully compensate victims. So there are limitations to that. But there is a system by which the victims can at least get some kind of financial compensation, restitution if it is possible, but financial compensation otherwise, which can be, that financial compensation can come either from assets used in the commission of the crimes or from a trust fund. The trust fund was created, I think, a year and a half ago, and is led by a board of directors which includes the Queen of Jordan, the former president of Costa Rica, Arias Sanchez, who now has resigned because of personal reasons, Desmond Tutu, the Archbishop, South African Archbishop, Simone Veil, who is a survivor of the Holocaust, and I'm missing someone. Yes, a former Prime Minister of Poland. So there is now a great deal of debate as to what exactly the Board of Directors can do, and indeed a great deal of debate about what a victim is. Is it a victim of a whole situation, or do you need to wait for the outcome of a judgment to know what the victims are? This is a very, very contentious debate right now, which we will know more in about 3 weeks when the Assembly of States Parties meets again. I think this is going to be a very important subject of discussion.
Lots of questions now, raising. This gentleman had his hand up.
Just come up for the microphone. Where does the court get its funding? Is that funding secure? Is it subject to political currents?
Well, we're better off than the Sierra Leone Tribunal, if that is your question. The funding is provided by the states parties, and the funding is based on assessed contributions modeled on the United Nations. That is, that it depends on the essentially level of economic development of states. The major contributor now is Germany. The second, I think, is the United Kingdom, and the third is France. On the other hand, the whole of Africa contributes 0.83% of the whole budget. States are late, as usual, but so far, I don't expect the financing of the court to be a major problem, in the sense that I think over time it's going to be, it will be the subject of automatic systems of payment as payments to other international organizations. The only difference is the pot is smaller because we only have 100 states, but that is the system.
Can I ask you a follow-up question to that? You now have 4 cases or situations. How many do you think are too many for the ICC to handle at one time?
Well, we're working on this. I was saying earlier that we're living with the history of others, And the history of the ad hoc tribunals has made states quite nervous in terms of the capacity of a tribunal or of a court to expand uncontrollably. So we want to reassure states, and we are developing a strategic plan which will tell states this is more or less where we are going. We also are going to develop a court capacity model which will essentially say, with these resources, we can accommodate 3 situations. If you give us more, we can accommodate 5. So I don't have a full answer to this. I think at this stage, 3 or 4 situations would be the absolute maximum, but we will know a little more when those studies are over.
How would it be possible to bring the state or actors on behalf of that state before the ICC if that state is not a signatory to the treaty?
Well, first of all, the ICC Statute, the ICC has only jurisdiction over individuals. It has no jurisdiction over states. And that, sorry?
I also included actors on behalf of the state.
Yes, I understand your question perfectly, but I think it is important to make it clear at the beginning that the ICJ has jurisdiction over states, the ICC only has jurisdiction over individuals. To answer your questions, you apply classical principles of international criminal law. Say that, okay, Canada, to take a state at random. Canada has criminal jurisdiction over its territory, we agree? So if someone is arrested in Canada, a foreigner has committed a crime, which is within Canada's jurisdiction, Canada will arrest that person. There will be no questions asked. If there is an extradition treaty between Canada and, say, Germany, and someone is arrested in Germany who is sought in Canada for a crime committed within Canada's jurisdiction, Germany may extradite the person to Canada. There will be no questions asked. It's exactly the same principle. You have an obligation on the part of states party to the ICC statute to arrest individuals if an arrest warrant has been issued against them, and to surrender the person to the court. And that applies to nationals of states parties or non-states parties, because it has nothing to do with treaty law, but everything to do with international criminal law.
Well, Philippe Kirsch is going to be leaving here in a couple of hours after our reception and going to New York to have his first formal presentation as President of the International Criminal Court before the General Assembly. And we wish you luck with that, and we thank you very much for your presentation today. And we will be moving across the hall that way to which room? A61 and 62 for a reception. Yes. That's terrific. Thank you. This is pretty heavy. See if you
I think I brought your offer.
It's a nice one. That'll look very nice in these.